week, an Idaho judge ruled Bryan Kohberger can face the death penalty if he is convicted in the murders of the 4 University of Idaho students despite his autism diagnosis.
Now, that diagnosis was conducted by a clinical neuropsychologist, and some have questioned whether Kohberger could use an insanity defense in this case. Fox 13's Shira Matsuzawa talked with an expert that explains why that can't happen.
Well, the short answer is there isn't an insanity defense in Idaho. It's one of the 4 states that don't have one, but aspects of a person's mental state do play a role in a person's criminal defense, and it can later come to consideration in Bryan Kohberger's trial as well.
Back in the 1970s, early 80s, we found that the insanity defense was being misused in Idaho, in my opinion, in drunk driving cases, in minor matters. Someone would assert that they did not know the nature and quality of their act.
Which is why former Idaho Attorney General, as well as Lieutenant Governor and current criminal defense attorney Dave Leroy, pushed for the state to repeal it. He says what would often happen is both sides would get their own psychiatrist or psychologist, which would often confuse the jury and leave taxpayers footing the bill on all of the cases and expenses.
I think it, over time, has probably saved the taxpayers of the state of Idaho potentially hundreds of thousands or even millions of dollars.
While there isn't an insanity defense in Idaho, a person's mental state is still taken into consideration before and after their trial.
We still, before a trial is had, if someone is so out of touch with reality that they can't aid in their own defense, have the ability to put someone in a mental health secure setting to try to improve their mental health to the point that they can go forward to trial. So if someone is not fit for trial, we don't try them as a criminal defendant.
In Bryan Kohberger's case, he has not been deemed mentally incompetent to stand trial. His defense, however, has previously asked the judge to remove the death penalty, claiming executing someone with autism would constitute as cruel and unusual punishment. Last week, the judge issued a written ruling that said in part not only has the defendant failed to show that autism spectrum disorder is equivalent to an intellectual disability for death penalty exemption purposes, he has not shown there is national consensus against subjecting individuals with ASD to capital punishment. He went on to write ASD may be a mitigating factor to be weighed against the aggravating factors in determining if the defendant should receive the death penalty, but it is not a death penalty disqualifier. Kohberger is charged in the murders of Ethan Chapin, Xana Kronodal, Kaylee Gonzalez, and Madison Mogan. If he is found guilty, the court can consider his mental state when determining his sentence. Earlier this year, Kohberger's medical and mental health records were handed over to prosecutors. The contents remain confidential, but some experts say those records could be used as a potential mitigating factor that spares his life if he is sentenced to the death penalty.
We don't disregard or pretend that people with mental illness don't commit crimes. We simply don't allow them to avoid conviction for a crime, and we deal with the mental health issues before or afterward in appropriate ways.
Kohberger's trial is scheduled to start on August 11th with the jury selection beginning in late July. In the newsroom, Shira Matsuzawa, Fox 13 News.